This recording, we are dealing with election petitions, and this being and us coming near to 2026 general elections, then this is a very good audio to watch. So please make sure that you listen at the end of this video. I will share basically the key principles that can help you to conduct a free and fair elections. And in case you want to win an election and your win is not overturned, then you are at the right place. So please listen up to the end as I take you through the whole process from nomination to campaigning, to elections, to counting the votes, and then finally setting aside an election. So during this week, students will be exposed to knowledge and skills required in the protection of the democratic rights exercisable through electoral processes, protection of citizens' rights against arbitrary and irregular exercise of public powers, discretionary remedy of judicial review, and constitutional interpretation. So we looked at judicial review in I think term 2, but that was in a passing. But now we're going to look at judicial review in detail. So by the end of the week, students will have one appreciated electorals and processes, enforcement of fundamental rights and freedoms, judicial review, and constitutional interpretation. Develop the ability to advise on pre-election and post-election remedies for election grievances, grounds, nature of evidence, procedures, forum, and documents. So we shall look at what are the pre-election remedies. For example, if someone has his nomination has been rejected, what remedies do you have? And also post-election remedies like ordering for recount, among others. Then we shall look at remedies for infringement of fundamental rights and freedoms, procedures, forum, and documents. If your rights being infringed, what remedy do you have? The judicial review and its scope, procedure, forum, and documents. Cause of action, remedies, principles of interpretation of a constitution, procedure, forum, and documents. Distinction between a claim for enforcement of fundamental right in application for a writ of habeas corpus and constitutional interpretation, and vulnerability to prosecute and oppose a suit. Remedies on election grievances, we have enforcement of fundamental human rights and freedoms. How do you enforce fundamental human rights? According to Article 50 of the Constitution, we can see any person who thinks that a right of a person is being violated, then he can proceed to petition court. Then we see now also judicial review. Judicial review is always by notes of motion and affidavit in support. I also have a writ for habeas corpus and constitutional interpretation. So develop ability to identify and deal with issues that are likely to arise within these areas of practice. So workshop 1, the workshop is on the people's democratic right to elect leaders of their choice and the leaders' rights to contest for elective positions under the law, such as member of parliament. The aims of the workshops are to broaden the students' understanding on the laws and procedures governing parliamentary elections, develop students' ability to advise and handle disputes on electoral matters, organize and handle ESCO matters in the area of practice. So by the end of the workshop, students will be able to examine concepts and principles relating to parliamentary elections, identify and weigh grounds on which pre-election and post-election remedies can be available to aggrieved parties, and effectively draft, file, and exchange necessary documents for effecting pre-election and post-election remedies, illustrate the process and opposition of an election petition, and organize and deal with ISCO aspects regarding to election petitions. So basically, the election petitions is governed by the Parliamentary Elections Act, that is Cap 177, and basically the key provisions we shall be looking at is Chapter 3 on qualifications, tenure of office, and right of recall. We shall also look at Chapter 4 on nomination of candidates. We shall look at Chapter 9, counting votes and announcement of results. We shall also look at Chapter 10, election petitions. Chapter 11, illegal practices. And and of other election offences. So basically, those are the parts of the act you should pay attention to. So assume you are an advocate at Kaswamburi and Company Advocates, or Team Job and Audit has phoned you today and narrated the facts below. Assume that on 30th of May 2025, the Electoral Commission conducted parliamentary election across the country for Manzi County constituency and Guru district. The election attracted 4 candidates. These are Team Job, sponsored by the NRM, Okara Sam, sponsored by NUP, Audit Bob Independent, and Okat Ronald Independent. So upon turning the results, the returning officer Baron Sana declared Okero Sam, sponsored by NUP, who scored 11,468 votes, as the re-elected member of parliament to Manzi County in Good District. He was followed by Team Joab, who scored 11,402 votes. Audit Bob, who scored 1,286 votes, and Okot Ronald, who scored 188 votes. So you can see the difference between the first candidate and the second and the first runners up, almost 62 votes. Upon declaring Okero Sam Noop, sponsored by Noop, as a successful candidate, the AC gazetted the name on 30th of July 2025 in Uganda Gazette. The candidate was duly sworn in and took his seat in Parliament. Otim Job, who scored 11,000 votes, and Audit Bob, who scored 1,000 votes, are before you. And at there, self-challenging the nomination, election, and declaration of Okero Sam as duly elected member of Parliament for Manzi constituency. In light of the foregoing, Otim Job and Audit Bob have further informed you that Okero Sam Nup was nominated on the 20th April 2025 with qualifications in the names of Mangas Moses Ayub, having obtained O-level by UNEB in those names, but later did certificates in plumbing, design, electricity under the names of Moses Muganda from Chambogo Polytechnic Institute. So basically, here we shall look at the eligibility for one to stand for MP. You must have acquired Uganda Advanced Certificate of Education or its equivalent. These 3 certificates qualifications were duly equated by the National Council for Higher Education to A level, and he holds the certificate from Che, but where Otim Job wrote to UNEB to compare the said qualification of A level, UNEB wrote back saying it does not know the existence of such qualifications in Uganda, nor has it ever seen any qualification of such from that institution, nor from Che. UNEB could not confirm the value of the said qualifications, nor could it dispel its value. Audit Bob informs you that he was informed by his campaigning agent in Kavuru village that the NOP candidate sent money to voters on their phones in the village 2 days before his nomination, and all the recipients of the money were available, stating that he was thanking them. You check that indeed their phones have mobile money transactions from the candidate's number registered in Okiro's Sam name. The recipient's number are registered in their names respectively as they appear on the voters register. Another voter called Oiyo Sam was also sent money on his phone from NUP candidate 7 days after the earlier batch of voters received money, and it was all for the same cause. So basically here you can see bribery. Once you send money to a person for the purpose of procuring the vote, then that can be bribery, contrary to the Parliamentary Elections Act. So paragraph 4, Team Job further informs you that at one of the polling stations, Kabgohe Primary School, which is a polling station, has the highest number of registered voters in Manzi's constituency. Okero's agent caused havoc in the middle vote counting, where NRM candidate was already having 200 votes counted, as opposed to the NUP's candidate who only had 18 votes, and when the presiding officer was remaining with about 10 votes to count, the process was disrupted, and that is how the whole exercise of voting ended, and the results of that polling station were not included. So you can see these people were disenfranchised by their right to vote. So when there was when there was a scuffle or a fight, then they stopped to count the votes, and then they proceeded to do what? They proceeded to count the other votes, but on that specific polling stations, the votes were not done. What? The votes were not counted. So, which is against the Parliamentary Elections Act, which is against the Parliamentary Elections Act when you don't count the votes of one polling station. Then we proceed. In another polling station called Kasubi 1 polling station, our team informs you that the results of the stations are very suspect. He informs you that his agent, Ugara Peter, informed him that the no polling agent Basude Somas, in connivance with the presiding officer, Stony James Powered, already ticked votes into the ballot box. So this one is ballot stuffing. Ballot stuffing is also an offense where some other ballot papers are put into the box, which always happens. Otim further informs you that at the said polling station above mentioned, the voters stated to have voted for female members of parliament, and the presiding are less by 160 votes than the votes cast for this contested election. Either said elections were conducted the same day. So now here we shall look at the declaration forms and basically how these votes were counted, and we would need a declaration form to prove that. Audit Bob informs you that the time of nomination he chose the symbol of a fist, and on the ballot paper he was allocated a symbol of a handshake of two hands. So also we can see that members have a right to choose the symbol which they want to, and this symbol cannot relate to cultural institutional practices, but they have their right to choose the symbol. So advise Team Job and Audit Bob on the propriety of Okello Sam's nomination by the Electoral Commission and his declaration as the winner of the parliamentary election for Kampala Central constituency. What pre-election remedies would you pursue in the circumstances? And B, the EC and successful candidates' actions and omissions and their effect on the proper conduct of the subject elections, as well as the entire outcome. So basically, as far as that issue is concerned, that part is concerned, we shall be discussing whether Okello Sam was validly nominated. We shall look at the issue of his qualifications, and basically we shall be governed by Section 30 of the Parliamentary Elections Act, which states that, read together with Article 8 of the Constitution, which states that for one to qualify to be nominated as a member of Parliament, you must be one, a citizen of Uganda, be a registered voter, and C, have completed minimum formal education of advanced level or its equivalent. And this has been re-emphasized or reiterated in very many cases. For example, in Asen Christine Ayo versus Abongo Elizabeth election petition appeal number 58 of 2016. Also in Sembati and Daura versus Mwanga election petition number 34 of 2016. I shall also deal with the issue of discrepancy in the names, which has been covered in the case of Mandela versus Ivan Bowe. The court held that the use of a statutory declaration is sufficient to prove and explain a misspelling of a candidate's name. But however, where you have added another name, that means you would need a deed poll. So the failure to have a deed poll might become an issue and lead to invalidating the nomination. Then the issue 2, whether Otim Job and Audit Bob have any pre-election remedies. One, you can lodge a complaint with the returning officer or commission under Section 32 of the Parliamentary Elections Act. States that a voter registered on the voters of a constituency may lodge a complaint with the returning officer or the commission in relation to any nomination in respect of the constituency, challenging the qualifications of any person nominated. Also, if you read Section 15, subsection 1 of the Electoral Commissions Act, it provides for these powers that you can lodge also a complaint to the Electoral Commission. Then B, the Electoral Commission and successive candidates' actions and omissions and their effect on the proper conduct of the election. We shall be looking at bribery and illegal practices contrary to Section 87 of the Parliamentary Elections Act. We shall look at the case of Chiza Besigye versus YKM7, where the Supreme Court guided that what amounts to an illegal practice is that the gift was given to the voter, that the gift was given by a candidate or his agent, and that the gift was given to induce the person to vote for the candidate. Also, this was emphasized in the case of Odo Tayebwa versus Nasa, Basajja Baraba, election petition number 13. So, also when you look at the case of Musingu Garuga James versus Amama Mbabazi, Musingu Garuga James, may his soul rest in peace, versus Amama Mbabazi, the court also retaliated the same principles. We also have Electoral Commission, the negligence on the side of the Electoral Commission, ballot stuffing contrary to Section 86 of the Parliamentary Elections Act, where a person puts more ballots in the ballot box. We have discussed this in a lot of cases. Turkit Simon Akech versus Orania Jacob Lakoli. Ballot stuffing was defined as an election malpractice which involves voting more than once at a polling station. Then declaration of results, Section 69(5). The declaration forms must be signed by the agent and presiding officer, and they must contain the votes of each candidate. Choice of symbol nomination, we shall look at Section 34(b) of the Parliamentary Elections Act, which provides that where an election is contested, the Commission shall, as soon as practicable, after the nomination, allocate a candidate who is not supported by a political party organization, a symbol or color chosen by him or her. So then shall also look at counting of votes, because when you don't count the votes of one constituency, that means you disenfranchised those people. So under the Constitution, every citizen has a right to vote. The effect on the proper conduct of the election, we can see Section 80, subsection 1 of the Parliamentary Elections Act, that an election can be set aside when there are illegal practices under that act. And this was also emphasized in the case of Dr. Chiza Besigye versus Yoweri Kaguta Museveni, Presidential Petition number 1 of 2006. So we continue to Asim Joban came to you in your chambers immediately after the election and before Sam Okello was gazetted by AC, advised them on the necessary course of action you would take and necessary documents you would file in court. So basically here we are looking at before the gazetting, one, how you can lodge a complaint at the polling station under Section 65 by the agents. You can also lodge an objection with the presiding officer, and also you can go for the magistrate recounting the votes by the chief magistrate, and the documents here would be a notice of motion and affidavit in support to recount the votes. The process, forum, and documents necessary in effecting the suggested remedy is a notice of motion and affidavit in support. Any additional information you need in the circumstances. So the additional information we need, the declaration forms, we need evidences of receipt of mobile money, among others, but those are some of the additional information we shall be requiring. The procedure, forum, and initial documents in effect that the procedure, forum, and documents necessary in effecting the suggested remedy, and in addition information, draft the necessary documents you will file in respect to the remedy suggested in 2 above. So in 2 above, we say that before gazetting, advise them on the necessary course of action you would take and the necessary documents you would file in court. So the remedies available to him in the circumstances. So assume Job and Bob came to your chambers immediately after the election and before Sam Okello was gazetted by AC, advise them on the necessary course of action you would take and necessary documents you would file in court. So we can go for a recount in the magistrate's court The remedy is available to him in circumstances. The procedure form and necessary documents in effecting the suggested remedy. Draft the necessary documents you would file in respect of the remedies suggested in 2 above. So basically, so we have going to the chief magistrate, and also petitioning court to set aside the election. Petitioning court to set aside the election. The remedy is available by him in circumstances. Declaration ordering for the recount in the chief magistrate, and petitioning to set aside the election. The procedure form and documents necessary in effecting the suggested remedy. Petitioning to set aside the election. Additional information, draft the necessary documents you would file in respect of the remedies suggested in 2 above. Then assume you were representing Okello Sam. What steps would you take to protect his seat upon receipt of the service of process? So after I have been served with the document as counsel for the MP who won, that means you have to file an answer to the petition. I have to file an answer to the petition, basically replying to that petition, which is always also in an affidavit, or an affidavit, what I can also call an affidavit in reply. So under Rule 7 of the Parliamentary Elections Act, you have to file an answer to the reply. You pay the necessary court fees, and then serve copy to the petitioner. Assuming that after the parties had filed their respective procedures, the petitioner approached you that intent to withdraw. So the Parliamentary Elections Act provides on the procedure of how you can withdraw your petition. First and foremost, provided the Parliamentary Elections Act provides that election petition shall not be withdrawn except with leave of court. So you need leave from court. Then the withdrawal should not have been induced by corruption, and also on hearing the application for withdrawal, any person may apply to court to be substituted for the petitioner. So basically that's how you withdraw an election petition. You basically need leave from court to withdraw the petition. So I think basically that was it for this workshop 1. That's basically what we shall be looking at. Assume Job and Bob came to your chambers immediately after the election, and before some occurred and gazetted by EC advised them on the necessary course of action. You will take and necessary documents you would file in court. The remedy is available to him in circumstances. We talked about going for the chief magistrate to order a recount. We talked about petition also. Petition will set aside the election. The procedure form and documents necessary effecting the suggested remedy. Any additional information you may need in the circumstances. That's the necessary documents you would file in respect of the remedies suggested into above. So that means we are going to draft a petition. So assume you were representing Okello Sam, what steps would you take to protect this seat upon receipt of a service process? Answer to the petition. Assume that after both parties had filed their respective pleadings, the petitioner has approached you that he intends to withdraw his petition. You need to get leave from court to withdraw the petition, and also any interested party can substitute himself the petition. So basically that was it for that. But also in case you want to receive notes and join our mastermind discussion, please you can contact me on the number on my bio, and then we can join our discussion, which is for paying of an affordable subscription fee, and we are also answering all the past papers. So workshop 2, the workshop will expose students on how to obtain remedies on wrongs committed under the exercise of public powers, as well as application of principles governing constitutional interpretation. The workshop aims at broadening students' knowledge on the rules and procedures for judicial review, enforcement of fundamental rights and freedoms, and constitutional interpretation. developing students' ability to handle disputes in these areas of practice, and organizing and dealing with ESCO issues. By the end of the workshop, students should be able to examine the various concepts and principles relating to the enforcement of fundamental human rights and freedoms, a writ of habeas corpus, judicial review, and constitutional petitions and references. Identify human rights violation, identify causes of action, prosecute and oppose an application for enforcement of fundamental rights, and draft, file, and exchange various documents, and deal with ESCO issues. So assume you are still an advocate in practice. Before you today is Benon. He's not happy with what he's going through. He starts seeking legal advice. One is he's the father of one Kites process, 16 years, both residents of Narmbai village, Jinja City. On 25th day of April, he was informed by the head teacher, Wanyana Girls School, the public school licensed by Ministry of Education and Sports, that the first term had ended and he should go and pick his daughter, who was studying at the said school in Senior 4. He was given the end of term bank slip for paying second term school fees, and his daughter's school report card. On the 12th day of May 2025, second term commenced, and Mr. Kasavante Benon paid Uganda shillings 800,000, which was part of the daughter's school fees for second term, and reported back to school for second term studies. On the 16th day of May 2025, the head teacher of Wanyana Girls School, one Miss Ayabazibwe Patricia, called Kitesi Prossi's mother and advised her to pick her from school on grounds that she was on indefinite suspension for a crime committed in first term, sometimes in April. Upon reaching school, the parents were instructed to take their daughter and leave the school premises immediately until further notice. The father informed you that her daughter had told him that she was not informed of the crime she committed and was never heard by the disciplinary committee of the school. When the parents tried to inquire from the head teacher, she told them that she had been informed by the warden, Mr. Joseph Mukisa Kitesi Prossi, was among the students whom they smelled alcohol, and she was found 3 months pregnant after the regular routine medical tests carried by the school. The father of the child, a fellow student, John Maneno, aged 16, was left to continue with his studies. The above is against the school policy of not allowing students to drink alcohol and engage in sex at school. Any students caught in such actions is liable to be expelled from the school. Mr. Kasavante Benon is unable with the head teacher's decision of indefinitely suspending her daughter, and he thinks you can help him. So first and foremost, this is a public school. The proprietary of the decision by the head teacher, Wanyana School, Girls School, the remedies available to him. So basically, we shall be looking at the decision of the director to expel in light with the right to education. Remember that under Article 30 of the Constitution, 30 or 31, provides for the right to education, and now this girl is being expelled. So here we have two remedies. One, we can go for judicial review to review the decision of the head teacher, but also we can go for enforcement of human rights under Article 50, where anyone seeks that the right of a person has been violated. You can go for enforcement of the human rights. So the remedies available to him: judicial review, procedure for necessary documents. So always for judicial review, it's always a notice of motion. Remember, for you to prove judicial review, we have the case of Berondem versus LDC. You must, and also Pastor versus Kabaya District Local Government. You must have illegality, irrationality, or procedural impropriety. Also have the case of John J. Tungaba, the West Macquarie University, where you can seek for mandamus, certiorari, prohibition, and declaration. And the documents are always a notice of motion and affidavit in support. So most probably here we're going to go for judicial review, because constitutional enforcement of human rights is not viable, but you can either go for judicial review or enforcement of human rights under Article 50. So here we have the Constitution, the Judicature Act, the Judicial Review Rules, Evidence Act, Civil Procedure Act. Then the next part, assume you are still advocating in practice. Just recently, the Parliament passed Uganda Armed Forces Constitutional Bill 2015, which was later signed by the President of the Republic of Uganda. The said amendment, Department of Court Reach Division and the General Court Department, headed by Chairperson General Court Department, who has supervisory powers. He further tells that of a recent, the Chairperson of the General Court Martial passed the guidelines known as the Constitution Bail Guidelines. Before in all practices, he tells you that he's among the 20 UPN supporters who are arrested. His rights or cause of action. So here we can go for constitutional interpretation. Article 137, any person who thinks that any law violates the constitution can go for constitutional interpretation. Documents and constitutional conditions for appropriate filing. The principles applicable to such actions, the nature of evidence. So basically, the document is always a petition. If you deem court action inevitable after the relevant documents, you would need to file. So it's always a petition under Article 137. Subsequent filing and serving the document into above, the wife of Mr. Nyambi comes to your chambers and says they are passed on. So considering interpretation, anyone can go. Even if the person dies, the matter can still continue. ESCO issues are not overcharging clients, among others. So basically that was it. That's what we shall be looking at in this workshop. Please, in case you want to join our mastermind group where we have notes and answer all past papers, reach me on 075 6767 please WhatsApp. Then if you pay the monthly subscription fee, you can be part of the group for that month. Please, I wish you success in your IA.